So I want to talk through some major milestones in the development of human rights and human rights law, and how it gets translated into international documents. And as we talk through this, I want to differentiate human rights law from humanitarian law, which is something we'll talk about later in the course. Humanitarian law really is about how states behave toward each other during times of conflict. It only applies in times of conflict, and states create humanitarian law out of a desire to mitigate conflict and create rules where if I follow these rules and you follow these rules, we reciprocally create a situation in which we're both better off and conflict is less awful. Whereas human rights law has a really different foundation, right? The foundation for human rights is sort of a universalist or natural law claim about rights inherent to human beings, and those rights apply at all times, and potentially bind states, not out of a reciprocal relationship with other states, but out of a recognition that there are limits to the rights of states to interact with their citizens. And as we kind of think through where this idea that human beings have these natural rights and the shape of these natural rights, where that came from, I tend to organize that conversation around this idea of these different generations. And I'm not really sure that that's the right way to think about it, but there have been at least three conversations that have spurred ongoing processes of realization around different kinds of rights. And so initially you get the Enlightenment and 1700, 1800, the American Revolution, the French Revolution, this conversation about what are the limits of the state? Like, how can the state interact with individuals? And we start getting this concept of democracy and of civil rights and civil liberties, right? And that's really aimed at this idea that there are limits to what states can do toward their citizens. In the 19th century, many states or some states go through a process of industrialization. There's urbanization. There's tremendous social and economic upheaval, and people push back against that and demand a set of rights that allow for them to exist within society. And so you see the rise of economic rights, whether that's the right to form a union or to be part of a union, but also things like, safe working conditions and a livable wage, and maybe healthcare, or a variety of different ways that these get manifested or articulated. But they're really a reaction to the horrors of industrialization. And then following World War I and World War II, you get a third sort of conversation that gets woven in here, which is a conversation around group rights and identity. That after World War I, Woodrow Wilson articulates this idea of self-determination, that groups ought to be able to form political units to represent themselves. You get after World War II the Genocide Convention that for the first time makes it a crime to target a particular group for extermination. And then you get the anti-colonial and anti-apartheid movement over the course of the 20th century that pushes back against structures and systems that are inhibiting groups of people from being able to organize politically. And so it's a different kind of conversation than what we've seen before, but none of these conversations supplants the other. They're all kind of moving along in parallel. When we think about sort of how this gets translated into international law, there's a couple sort of important milestones, probably the biggest of which is the Universal Declaration of Human Rights, which is adopted in 1948 by the UN General Assembly after a process of really intense negotiation and collaboration to generate this sort of foundational list that's going to be the basic structure around which international human rights law is built. The intention was that this would be the starting point, that a lot of these ideas would be a springboard to articulate more developed and more robust frameworks. Some of those rights were focused on economic issues, some were focused on individual issues, civil rights, civil liberties kind of things. But a different way to maybe splice it would be to think about prescriptive rights versus proscriptive rights. And particularly when thinking about what are the obligations of states in terms of ensuring that these rights are realized by their citizens. Prescriptive rights are things that are good, things that states should strive to create. We might call them positive rights, things that require some effort to make the space for. And there's kind of a recognition that goes along with these prescriptive rights that not all states may be able to achieve these immediately. That there may be economic concerns, there may be stability concerns, there may be just functional capacity concerns, and so states might not be able to ensure that all citizens have a safe environment, or they have a living standard, economic standard of living that's survivable. That might not be possible for a state to provide to their society at a particular point in time, but there should be an ongoing process of realization toward these prescriptive rights, that it is an obligation of states to try to create the structure and the system for that to be realized for people. Proscriptive rights, by contrast, the pro is like prohibition. It are things that states are told you cannot do. You cannot block this. You cannot use your power to run roughshod over the rights of people. Sometimes these are called negative rights. And these things, in theory, right, all states should be able to provide to their people immediately, and there should be no barrier to being able to do this, right? So people having a right to not be tortured doesn't require states to have any particular level of development or any particular level of state capacity. They just simply have to not torture, and that proscriptive right can be realized by the state restraining itself from using power against people in a particular way. Likewise, the ability of people to freely associate, or to the freedom of speech or freedom of religion kind of things, simply require governments to not act, which in theory everybody can do, even if governments might find it inconvenient to do these things at different points in time. They could be, in theory, immediately realized. So in addition to the Universal Declaration of Human Rights, which lays out some proscriptive and prescriptive human rights, there's been a whole host of additional documents that have been built up to kind of flesh these rights out. Initially coming out of the Universal Declaration of Human Rights were efforts to develop two protocols that would really expand on the Universal Declaration of Human Rights. There was the International Covenant on Civil and Political Rights, which focuses primarily on those proscriptive rights. And then there's the International Covenant on Economic, Social, and Cultural Rights, many of which are prescriptive rights. And maybe it makes sense to separate those things out. It also kind of reflected the dynamic of the Cold War, where the United States focused primarily on civil and political rights, and the Soviet Union tended to emphasize the economic rights primarily, but to a lesser extent, social and cultural rights. So there was that tension about who was more appropriately fulfilling the promise of human rights and could claim that mantle. But there were also a whole bunch of additional conventions and protocols and agreements that have been put in place since. Initially, you get the Convention on Prevention and Punishment of the Crime of Genocide. That's an immediate reaction to World War II and the crimes of the Holocaust, and gets articulated for the first time in international law. But then following the two protocols on civil and political rights, and then on economic, social, and cultural rights, you get a return to this idea of additional conventions, additional agreements that are going to address specific problems that aren't captured in those general protocols. And so in 1979, you get a convention on the elimination of forms of discrimination against women. You get, in 1984, a convention against torture. And then in 1989, you get a convention on the rights of the child. There's a number of others. There's a convention on migrant workers, which the United States hasn't signed. I like to flag what the United States has signed and hasn't signed. It hasn't signed the Convention on Migrant Workers. It has signed but not ratified the Convention on the Rights of the Child, so the U.S. has symbolically said it supports it, but the U.S. Senate hasn't agreed and provided a ratification vote. The Convention on Torture, the U.S. has signed and ratified. The Convention on Women has been signed but not ratified. The Convention on Racial Discrimination has been ratified, but with reservations. So this is something that states can do, is that they can ratify an agreement, but put sort of a side note that says, we disagree with a certain part of this convention and don't consider it to be binding on us as part of our terms for agreeing to sign on to it. I'll note that ratification in the United States is a fairly high bar, and so it's not entirely surprising that the United States hasn't signed and ratified all of these agreements. It did sign and ratify the Civil and Political Rights Convention, although there's an optional protocol that the United States hasn't ratified. And it is a signatory but not a ratified member of the Economic, Social, and Cultural Rights Covenant. So a lot of different agreements that all collectively add up to this idea of international human rights law. There is additional case law that comes through international human rights courts. There are additional writings from legal scholars, because as we've talked about, thinking about international law isn't just about the formal agreements that states have signed on to. It's also about the combination of practice. It's also the combination of all of this larger legal infrastructure around it. But collectively, that adds up to probably the most robust system of human rights law that humanity's ever assembled, and it continues to grow and be developed.